So actually, before we begin, is there the usual sort of parties agreeing on procedure, or is it fixed by the rules?
Parties have agreed to the procedure, Professor Chen.
Okay, and what's the procedure?
So, firstly, A. Ramesh Kanna, represent the appellant, Mr. Antonio Fortuna, together with my co-counsel, Mr. Brandon Zhang, and we will each be speaking on the first two pairs of the issues for 10 minutes each, respectively, reserving 1 minute for rebuttals.
Okay.
If I may begin.
Uh, yep. Go ahead.
Professor Chen, the case that confronts us today requires you to take a stance on the sliding scale between procedural justice and substantive fairness. Now, we do acknowledge that in the vast majority of these cases, the position to be taken is concretized based on the FDC and the CAS code. However, this balance does shift with exceptional circumstances. Thus, the heart of the contention today is whether the case that confronts us now falls within these exceptional circumstances. And our position is yes. In this regard, I make two submissions. Firstly, the statement of appeal is admissible. And secondly, Mr. Antonio Fortuna's refusal to submit his phone is not unlawful. Now, with regard to my first submission, I make it on two grounds. Firstly, the filing was attempted within the deadline. Secondly, the reinstatement should be allowed. Now, the deadline for the statement of appeal is concretized under Article 50, subsection 1 of the CAS Code. It is 21 days after the receipt of the final decision. The first contention that arises is whether the filing was attempted within the deadline. Now, opposing counsel may contend that the final decision was on the 31st of March, and thus the deadline ends on the 21st of April. However, decision as per R31 of the CAS Code is defined as decision with full grounds. Thus, the 21-day window only begins on the 2nd of March and ends on the 23rd of April. This was
So on this issue, I mean, it's a question of admissibility, right? So, how much discretion does the tribunal have over this matter? Are we uh at the mercy of whatever the dates are, or do we have some overriding powers?
There are overriding powers, Professor Chen, and
And
these
where,
powers come into play if two elements are met for reinstatement. Firstly, the instance of disorder should not have been caused by any fault of the appellant. And secondly, the appellant's counsel must have been prompt in requesting for reinstatement. This two-element test has been stated in the 2024 CAS decision of FC Football Club FSCB and Galatasaray, and the 2019 CAS decision of PFC and UEFA.
I mean, okay, so as on a more general note, when it comes to matters of time, it usually boils down to, are there good reasons for the delay? And I know your submission is kind of like there's no delay to begin with, but since there's a question of whether it falls within the time, that's one aspect, right? The other aspect would be what would be the harm or prejudice occasioned if we do allow admissibility? So what's your response to those two factors?
Well, with regard to good reason, it would follow the two-element test, and your intuitions are well-founded in that there is a harm, as explained by my initial submission on the sliding scale. If this statement of appeal were to be admitted, it would be hurting procedural safeguards. However, this is allowed because the principle of equal treatment is not affected in our case. In our case, the email failed to be sent to the CAS office, not because of any fault on the appellant, but rather due to a third-party cyber attack. And CAS jurisprudence recognizes this sort of situation as one which the panel can intervene and decide that the procedural safeguard can be breached through reinstatement.
All right, so that what jurisprudence are you referring to? Which is the most instructive?
The most instructive case would be the SFT, the Swiss Federal Tribunal case of Christina Iowa, which also involved a situation where there was a failed email filing. However, in this particular case, the email was failed. The email filing failed not because of a third-party cyber attack, but because the security certificate had expired. Now, the security certificate expires at a set period of time, and it was the appellant counsel's fault in not renewing this particular certificate in time. However, this is distinguishable from the present case, where the third-party cyber attack was unforeseen. Beyond the natural protections and procedures that a law firm would have against such cyber attacks, the appellant's counsel did not have the foresight that was necessary to take any other preventive measures towards this cyber attack. And the principle of foresight is what is central to the no-fault limb of this two-element test. Now, with regard to promptness, we were only informed that a cyber attack could have prevented the filing of the email on the 26th of April. This can be seen in PDF page 52, Exhibit 9. If I could turn Professor Chen to that page.
Yeah, which page again?
PDF page 52.
52. Yes.
So here it can be seen that the IT staff does not say with certainty if the attack had indeed prevented the filing and if the situation had even resolved. So opposing counsel would now seek to say that the 2-day delay between the seeking of reinstatement and knowing of the disorder was not prompt. However, there are a few considerations to be taken into account. 26th of April is a Sunday, and the first working day after which this information was made known is the 27th. So the so-called delay is only a gap of 1 day. And this 1 day was required by the counsel in order to determine if there was indeed a cyber attack that prevented the email filing and to fix and restore the systems so that a proper email could be sent. Now,
Right, but couldn't there have been the interim measure? Couldn't you have told someone have told somebody that there might be a delay? You don't know how long the thing might be down for. Was that done?
On the facts, this was not done, Professor Chen. However, our argument would be that this was not a necessary step in order to meet the promptness threshold.
Why not? Because if you think that there is a risk that there might be an unpredictable duration of a delay, wouldn't it be in your interest to notify the recipient that there might be some delay? At least they're put on notice.
We understand the concern, Ms. Professor Chen, and in this regard, we had sent a hard copy via courier as well, which had indeed reached on time. Thus, we would argue that it was not central to the promptness requirement for us to have quickly inquired about whether the electronic filing was sent.
Right. And how about some sort of I mean, compensation is not the right word, but some sort of a cost order for indulging in this admissibility application because there is some inconvenient occasion. Is that within our remit, or is that only in other kinds of civil litigation?
It is within the panel's discretion, Professor Chen.
Okay, and what's your submission on that? Would you accept that if we permit the statement, then there should be a cost order? And if there's a cost order, what might be the conditions be for the cost order? For example, would we tie it to the outcome of the dispute, or would we make an ad hoc cost order at this point?
The central tenet of this requirement is equal treatment of the parties, Professor Chen. So if the reinstatement in some way prejudices opposing counsel in not getting equal treatment, then the cost would be warranted, and it has to be quantified based on the amount of prejudice suffered by the opposing counsel. However, we would argue here that the reinstatement, or rather the delay, was not caused because we had more time to file the statement of appeal, but rather due to us being obstructed by a third-party attack, a malicious attack. Thus, in this case, allowing for reinstatement restores equal treatment of the parties rather than to disrupt it. Now, if there are no further questions, I note that I have 1 minute left. If I could request for 1 more minute, I would like to sum up my submissions under the second issue.
Yeah, I'm happy to take more than that. Let's see how it goes.
Thank you, Professor Chen. Now, with regard to my second submission, I make it on two grounds. Firstly, the refusal to hand over the phone was aligned with the Article 6 ECHR protection of privilege against self-incrimination, and secondly, it was aligned with the Article 8 ECHR protection of right to privacy. Now, why Article 6 of the ECHR is relevant is because this panel is seated in Switzerland, and any decisions made today can be annulled by the Swiss Federal Tribunal, which is ultimately bound by the European Convention of Human Rights. Thus, Article 6 and Article 8 are immediately relevant within this proceeding. Now, the underlying principle behind Article 6 is that the privilege against self-incrimination is an international standard of procedural fairness, regardless of whether the accused is indeed guilty or not. It is to avoid oppressive fact-finding that is against the will of the accused. This was stated in the ECTHR Article 6 guide. Now, we acknowledge that Article 6 is only applicable in criminal proceedings against the state, and on first notice, may not seem the most appropriate in a case against FIFA. However, we are not arguing that the appellant has a privilege against self-incrimination with regard to FIFA. Rather, the evidence collected by FIFA against the appellant's will can prejudice the appellant's right against self-incrimination in the parallel criminal proceedings that the appellant is facing with regard to Iridonia's public prosecutor. Now, such an application of the right has been accepted in prior cases, such as the 2017 CAS decision of Jerome Balke and FIFA, which also involved a refusal to cooperate with FIFA in the context of a parallel criminal proceeding. Now, the panel in that case determined that such an application is only applicable when there is a clear and imminent danger that evidence collected by FIFA will be sent to the public prosecutor's office. In our case, FIFA immediately upon receiving the anonymous email attachment sent it to the public prosecutor's office. Do note that this is in breach of FIFA's own confidentiality regulations under the FDC Article 34, if I could refer Professor Chen to that particular article.
So, I mean, yeah, go. Are you still making the point about the article or?
Now, given that FIFA's disciplinary committee was willing to breach their own regulations,
Yes.
sending over evidence, we would argue that the appellant was right in not handing over his phone, as there was a real and imminent danger that the phone's contents could immediately be sent over to the public prosecutor's office as well.
Okay. Is there anything else on the European Convention? I mean, because I had some questions, but I just want to hear the whoever other else you think is important.
The second line of argument would be that the refusal to hand over the phone was also aligned with Article 8's protections. Now, Article 8 protects an individual's private life and correspondence. And in today's day and age, one's phone can be considered a personal diary. Now, we are not contending that the appellant should completely reject the request to hand over his mobile phone. However, FIFA is essentially seeking access to all of Mr. Fortuna's private communications, photos, and personal data unrelated to the cooperation with the investigation. Thus, its actions can be deemed excessive when balanced against the interests involved. Now, this is not appropriate, as seen in the 2017 CAS decision of Jerome Balke, which states that investigative procedures should be proportionate. Now, in the present scenario, if FIFA had requested a specific set of data from the mobile phone, then the appellant would have indeed cooperated. However, the fact that it was an absolute position put forth by FIFA, it is clearly barred by the Article 8 application. Thus, we would argue that the appellant was not unlawful in denying the request to hand over his phone.
Okay. Can you hear me?
Yes, I can hear you, Professor Chen, but your screen is frozen.
Yeah, probably my computer trying to run updates again. But since you can hear me, I have a couple of questions. solution uh, to to uh, to this dispute, right? Because wait, hang on. The Zoom is now popping up all sorts of messages to me. Don't send. Okay, yeah. Yeah, the applicable, because earlier you did mention that there are some CAS cases that refer to the European Convention, but I am a little skeptical about the applicability of the European Convention, right? So for both for Article 6 and 8, because typically the obligation is owed by the state to the individual, right? It's not owed by FIFA to the individual. So how do we overcome that? We will start with this question and then move on along.
Professor Chen, I understand the question, and it is indeed true that Article 6 and 8 can only be applied within criminal proceedings against the state. However, we are not contending that FIFA has to provide this particular privilege to the appellant. That would be legally misguided because this privilege does not even pop up within this context. However, what we are contending is that FIFA's investigative procedures should not breach the appellant's right to enforce this privilege within his criminal proceedings. Thus, FIFA is not in a position where they have to provide this obligation for the appellant.
Yes, I understand that. So because let's suppose that the state in question here is not based in Europe, right? And then maybe it's another state and the person wants to argue that he or she has a constitutional right. Right? So do we also need to indulge in that and say, well, it's not so much that FIFA owes this person constitutional rights, but this person also has some human right traceable to some other instrument, to why should that be a concern for us?
I understand the question, Professor Chen, and the second scenario that you have provided is vastly different from the current one because FIFA is seated in Switzerland and the CAS decisions that are made today can be annulled by the SFT. In essence, the Swiss Federal Tribunal is the highest court for this particular issue. And since the Swiss Federal Tribunal is bound by the European Convention, this particular Article 6 right and privilege is applicable to the current proceedings, and thus they should be respected. It is not a scenario where it is vastly different from a scenario where the constitution of a different country that Switzerland is not concerned with has to be applied within Switzerland proceedings. In the present case, the privilege that we are seeking protection from is one that Switzerland itself recognizes.
Okay, now let's move over to the other questions regarding 6 and 8. So 6 ultimately is about a right to a fair trial, right? And I mean, yes, I hear you on how you're not arguing that the individual is invoking the privilege against FIFA, but on an even more fundamental level, does the right to fair trial even include um that privilege, you see? Because when that privilege is triggered, typically is upon arrest, right? Or something equivalent. So here he's only being investigated by FIFA. So unless there is in terms of the criminal proceedings, the parallel criminal proceedings, unless he's also at the being investigated stage, would he really have a privilege against self-incrimination?
Professor Chen, with regard to this question, the parallel criminal proceedings are also still at an investigative stage.
Okay, so you're saying that because of that, he would have that privilege across
Yes.
different kinds of.
And to answer the first part of your question on whether this even falls within the right to a fair trial, the Article 6 ECTHR guide explicitly defines this as an international standard for fair procedure. And the reason for this is because the international community recognizes that in criminal proceedings, the public prosecutor should not oppressively use the state's machinery to obtain accusatorial evidence against the will of the accused.
Okay, let's move to Article 8 then. Yeah, what exactly is the interference here? Because Article 8 is about respecting someone's privacy. Um, I mean, surely that can't be a carte blanche against being investigated, right?
We agree, Professor Chen. We agree wholeheartedly, and that is why we state preliminarily that we do not argue that Article 8's protection allows the appellant to not hand over his phone at all. Rather, what Article 8 does is to provide this principle of proportionality, where FIFA should not be allowed an absolutist stance such that they can ask for the handover of the entire phone's contents. Because in this particular case, the only relevant contents are, if any, the appellant's communications with his father and the appellant's communications with the alleged syndicate. Thus, it was well within FIFA's ability to just seek evidence from these two avenues within that phone. However, they did not do that, and they breached the principle of proportionality that CASP jurisprudence recognizes by asking for the entire phone. And that is why we conclude that the appellant's refusal was not unlawful.
Is that realistic though? I mean, typically, if you want to get evidence, and the evidence is found in a phone or a computer, then you just take the phone and computer, right? You might give certain undertakings not to retain information that is not relevant, but this is not like, say, a warrant, right? Where you get a court order, you go to someone's house and you say, based on the warrant, these are the things you're allowed to search. But in a phone and a computer, wouldn't that be best resolved by having FIFA give an undertaking not to abuse their rights rather than to say that, well, because it might be disproportionate, the person is entitled to withhold the phone?
Uh, Professor Chen, I'll answer that question in two parts. Firstly, the impracticality point that you brought out, which is that it is impossible to isolate the data without having the phone. This particular point was addressed by FIFA on themselves when they sought the mobile data from the appellant. Thus, they were willing to just allow the appellant to send over the mobile data from the phone instead of providing the device as a whole. Now, this shows that it was well within their ability and procedure to restrict the data that they could request for. And secondly, with regard to... Apologies, give me a moment, Professor Chen.
Yeah, I mean, I was referring to comparing to warrants and whatnot, if that helps.
Yeah. Thank you, Professor Chen. With regard to the idea of warrants, no such undertaking was taken by FIFA. And this is also within the context where members of the FIFA disciplinary committee had already breached the article of confidentiality within their own FDC regulations, and no action such as suspension or sanctions had been made against any of the disciplinary committee members, as per Article 34 of the FDC. Thus, as a first layer, no undertaking was provided, and as a second layer, the members on the disciplinary committee could not be trusted to keep within their word by the appellant.
Okay, that's it. Thank you. I'll be back. Yep.
Good afternoon, Professor Chen. My name is Brandon Zhang, as introduced earlier, and I appear for the appellant. I will make two main submissions. First, on issue C, we submit that the respondent's case relies on anonymous evidence and unverified evidence, which under settled caste jurisprudence is insufficient and alternatively carries no evidential weight. Second, on issue D, even if the panel were to accept that the match itself were manipulated, we submit that the respondent has failed to prove the appellant's individual involvement to the standard of comfortable satisfaction required under Article 20 of the FIFA's disciplinary code. I now turn to the first submission. We submit that the anonymous evidence is inadmissible for three reasons. First, caste jurisprudence applies a strict safeguard with respect to anonymous evidence. Second, these safeguards have not been established. And lastly, in the alternative, even if admitted, carries no evidential weight. When the findings are based on anonymous witnesses, the right to be heard, which is guaranteed by Article 6 of the European Convention of Human Rights and Article 29, subsection 2 of the Swiss Constitution, is affected. And this has been recognized in caste jurisprudence, for example, in the Jerome versus Valky case. The underlying principle is that the equal treatment of both parties, and there is a need to strike a balance between procedural rights of the party opposing the witness anonymity, and on the other hand, the necessity to protect the life and personal safety of the witnesses on the other. There are 4 strict conditions which must be met in order to admit anonymous evidence. In the 2019 Court of Sport, hereby referred to as CAS, decision of Karim Karamuddin versus FIFA, at paragraph 129, the panel held that the use of protected witnesses is subject to the following 4 conditions: necessity, risk of retaliation, identity verification, and cross-examination. The respondent relies heavily on 2 cases: the 2019 CAS decision of Karamuddin versus FIFA and the 2009 CAS decision of FK Pobeda versus UEFA. In the Karamuddin case, at paragraph 133 to 135, the witnesses were victims of abuse, assault, and harassment. However, in that case, appellant was granted the chance to directly cross-examine them by phone with a voice scrambler, and a CAS counsel was physically present to verify their identities. In the 2009 CAS decision of FK Poveda versus UEFA, the witnesses were also personally exposed to threats, insults, pressure, and intimidation, yet the appellants were able to directly cross-examine them, and there was a counsel of the CAS present to verify their identities.
In those cases, did the level of threat that the witnesses face, how does it compare with the present case where, when it comes to match fixing, you are really talking about potentially, gangs and mafias, right? And the likelihood of violence is arguably greatest.
In those cases, the appellants in the Karamuddin cases were granted asylum. The witnesses were sexually abused in that case by the president of the Afghan Football Federation. And in the Pobeda case, there was also direct threats and intimidation. But to answer your point, Professor Chen, here in this case, those safeguards are not met. But crucially, in our case, there is no threats. According to the Exhibit 2, these are only rumors that the father is engaged and connected to a criminal organization. If I may now direct Professor Chen's attention to Exhibit 2, PDF page 32 at paragraph 5.
Yeah.
if it states my identity cannot ever be revealed. And this is fatal. The witness refuses cross-examination even though the CAS offers audio-visual protection system. The panel has not verified the witness's identity, and the witness has not been questioned by the panel, which is a requirement laid out in the Pobeda and Karamutin case. And at paragraph 6, the witness relies on rumors, invokes the phrase snitches get stitches. However, here there's no threat, no contact, no intimidation, and no objective evidence of risk. And this falls short of the concrete danger required under CAS jurisprudence. And
Well, this is a, a, a play of the national team, right? The anonymous witness. So I can imagine how in the foreseeable future, the person might be, what's the word you call it, alienated or even ostracized or sidelined, if it's found that, he has made this accusation. So apart from the security threat, I mean, there's also a potential threat to his livelihood, right? That he might be outcast as a result. I mean, it's speculative, but I don't think it's a completely improbable thing.
in the alternative, we submit that even if the panel admits the evidence, it carries little evidential weight. And this is because these are simply rumors that have not been established. And insufficient evidence is still insufficient evidence, regardless of whether there are other evidence to support this piece of evidence. And the respondent argues that internal consistency compensates for the lack of cross-examination. However, and the respondent argues that the witness was coherent, acknowledged limits, and avoided exaggeration, that this allowed the panel to assess its reliability. With respect, internal consistency only shows absence of contradiction and does not test the accuracy or credibility of the evidence.
Right, but I mean, wouldn't that be your obligation to show contradiction? Because I can accept that untested, unverifiable information needs corroboration. But if the respondent can show some internal consistency and therefore some level of corroboration, doesn't the onus shift to you to show that the evidence can be contradicted?
Yes, Professor Chen, the evidence can be contradicted. If I may refer Professor Chen to Exhibit 2 at paragraph 9. This
Okay.
is page, I believe it's just at the next page, paragraph 9. Here, I quote, Mr. Antonio Fortuna tells his father to stop pressuring him, shouting he could not go along with him in everything, and he could not hear what his father was telling him. So 2 points. Here, this evidence directly rebuts the allegations. He refuses to cooperate with his father. And secondly, the evidence has been taken out of context. The witness does not know exactly what the context of the conversation was.
Okay. How about other parts of the record? Is there anything else that either shows or cast some doubt on whether there was match fixing in terms of the appellant's involvement?
With respect, in Exhibit 5, this is the public prosecutor's office. This is Exhibit, I believe it's on page 36 of the PDF.
Yes.
In the third paragraph here, investigators confirmed that Mr. Luck Fortuna provided access to his Dogecoin wallet. And therefore, the appellant's father directly provided his wallet to the prosecutor's office. And therefore, he is open to cooperating to prove the innocence here. And moreover, in Exhibit 6, at the next page, 2 pages over at page 39 at paragraph 10. Here, before the game, he was under the weather and he consulted a doctor to play, and he decided to still play for the doctor. And Professor Chen, lastly here, there are two more points I would like to address. At paragraph 2 of the record, page 2 of the record at paragraph 2, he was the backup goalkeeper for the men's Aridonian national team because the starting goalkeeper had been out due to a injury. If there are no further questions, I will turn to the next submission.
Yeah, just go on first.
The respondent alleges my client of match fixing. However, we submit that my client is not guilty because for three reasons. First, the evidence does not meet the threshold of comfortable satisfaction. Second, the betting genius analysis report itself does not constitute match fixing. And third, performance analysis does not provide the evidentiary link required to prove guilt. The applicable standard of proof is comfortable satisfaction. In sports law, that is higher than the balance of probabilities, but less than the criminal standard beyond a reasonable doubt. However, it's been recognized that this sits at the higher spectrum, slightly under the criminal standard. And the panel held in the Pinkovsky versus LLF cast decision that match manipulation and player participation are legally distinct questions. The respondent has to prove a direct link, even if the panel finds or if Professor Chen finds that the game has been manipulated. The betting Exhibit 1 contains the betting report that the respondent relies heavily on. That betting report itself only reflects betting behavior and not player intent.
But I mean, what's the methodology of that report? How do they come to a particular conclusion? Presumably they would rely on some intelligence apart from data and statistics, right? Because for them to make so many claims with respect to potential match fixing, what or are you telling me that this this is just smoke but no fire?
There's two elements that has to be met for match fixing. First, there has to be established that the game was manipulated, and that is done precisely through the betting analysis report. Yes, we can accept this. But then second, when the match is considered manipulated, there has to be a link to prove that the player was involved. And here it has not been proven. If I now may turn to the facts of the case here.
Sure, but as you do that, I mean, consider, of course, if there are no other competing suspects, then wouldn't the doubt be cast on the appellant? So yes, go ahead.
Thank you, Professor Chen. Excellent question, because I was going to precisely address this issue here in the match. In the performance analysis section of Exhibit 1, there is questionable performance from 3 players on both teams, Iridonia and Cometland. Here at page 15, we see in the performance analysis section here.
Yes.
At minute 11:01, Royce miscontrolled a routine short pass. At 61:54, Cometland's forward Reyes made a run to meet the cross at near post. Despite having a clear path to tap the wall, the forward awkwardly attempted to backheel the ball, and it ended up rolling out of play. At minute 82, the Iridonia's defender Paul attempted a diagonal back ball kick towards his own goal under minimal pressure. And at the very last line, The effort was well saved by the Iridonian goalkeeper Fortuna, and therefore there has been suspicious performance by other members on the match. And in the case of Oleg's versus LFF, the panel stated that there may be other players involved, and even if there was manipulation found, that would not necessarily mean that the appellant was involved or could be ruled out that there was match manipulation.
What's the practice of sporting tribunals with respect to such reports? You know, are they typically given much weight, or are they taken with a grain of salt?
The CAS panels has held that the betting report and performance analysis itself, by itself, is insufficient to make out a claim for match manipulation. And in Ofusu Apaya versus FIFA at paragraph 109, the panel also held that poor performance and errors errors in the part of a football match does not automatically establish manipulation. And if I may now refer Professor Chen to the previous page 15 of the PDF, just last 2 points here for your consideration. At minute 64, the last line, no individual errors were identified. This is the second goal scored. And at the third goal, 88, minute 13, here at the third line, Santiago pulled up with an apparent hamstring injury. And the last line says, not a performance error. The inability of Santiago to continue his recovering run led to a goal being scored. And therefore, the analysis exculpates rather than implicates my client. And more importantly, no agreement has been proven, no communications with fixers, no benefit to the appellant has been brought forth by the respondent. And the highest is that the respondent is that it raises suspicion about the match. However, it never proved any individual intent or actions that my client match fixed in the case. And CAS jurisprudence has been clear that suspicion cannot alone be proof. Accordingly, we submit that there is no violation of match fixing under Article 20 of the FDC, and the issue must be resolved in the appellant's favor. Unless I can assist Professor Chen any further, this brings me to the end of my submissions.
No, I think that will be all. Thank you.
Thank you.
He'll let you go like that all day. Can you give me the that card, please?
Can you drop your seat down a bit? Same size. Yeah. Okay. Can? Yeah. Okay. Thank you, Nicholas. Good afternoon, Professor. Are we audible?
Yes, yes.
Shall I begin?
Please.
Good afternoon, Professor Chen. My name is Maxwell Peter, with my co-counsel, Mr. Austin Seah. We will be covering the two topics, the two issues of issue A
and I will be covering the two, issue A and issue B, and my co-counsel will be covering the issue C and issue D. I will address the two issues in 10 minutes and will be reserving 1 minute for rebuttal. Now, on issue A, our submission is straightforward. The appeal is inadmissible for three independent reasons. First, the statement of appeal was not filed within the time limit and the deadline, which was 23rd April. Second, the reinstatement should not be granted because the request was not made promptly. And last, even if the statement was rescued, the appeal brief was filed late under Rule 51. Now, we accept that the appellant's starting point under Article 50, subsection 1 of the FIFA statute, that the time runs from the receipt of the full grounds, and in these facts, the operative deadline of the statement of appeal is 23rd April. But the problem here is very simple. CAS never received the email, and there was no filing done. If I may take the panel to record paragraph 29, page 5. Here, the CAS Court Office states that it never received the appeal email and had not registered the appeal even by the 28th April date. Under the CAS Code Rule 31 for electronic filing, a statement of appeal is valid only upon receipt by the. This is exactly the point made in the 2022 CAS case of Hungarian Football Federation and FIFA. An email filing must enter the recipient's sphere of control, and here that never happened. And according to, if I may lead Professor Chen to record paragraph 31, page 5, here the appellant requested reinstatement. That request itself concedes that the filing was not made on time. So on the plain record, the statement was out of time and is invalid. Now, even if the panel were to assume and consider reinstatement, CS should be reluctant to grant because its deadline exists to protect equal treatment and legal certainty. And if CS were to accept such requests, it would erode the framework of the very substance which CS stands for. Now, I understand that my opposing counsel mentioned the case of FC, FCSB, and Glatzeri. But I would like to highlight that in this case, the two cumulative conditions were the hindrance must not be made at the party's fault, and second, the party must seek reinstatement promptly once the hindrance ends. FIFA does not contest the first limb, but we contest the second limb, which is there was no prompt action. Here we see, according to EVC, that they were informed of the cyber incident and the possible consequences on 26th April, according to Exhibit 9, PDF page 52. Yet they only contacted the CS Court Office on 28th April, which was a Tuesday. So I understand that my opposing counsel mentioned that they needed 1 day to readjust to what is going on, but they could have just made a simple call. They could have just sent an email updating the court office that this is the issue they are facing. But in this case, we do not see a prompt action from them at all. And they also mentioned that the 2 days is too long. The promptness means immediate action once they know the problem. Here, they knew that there's a cyber attack, but they still did not take any valid action. Rather, they just waited until the systems went back online. And now, moving on to the appeal brief, which was filed late under Rule 51.
So before we go there, then,
yes,
as you might have noted, I had asked the opposing counsel whether this court or rather this tribunal has a discretion with respect to matters of time.
Yes, Professor.
And if we do, how should that discretion be exercised?
Professor Chen, the discretion should be exercised sparingly. And in this scenario, it should not be exercised at all, because we see from the record itself, the appeal brief was even the appeal brief was submitted late, which goes to show that it was not only because of the the system failure or the virus which was infecting the affecting the Mr. Fortuna's Counsels system, but rather he himself was just applying and submitting everything late. We also see that if we also note that if this were to be allowed, it would erode the system from within itself, because CAS stands for the equal treatment and legal certainty. Whereas in this scenario, we do not see that happening. And in the case of PFC and UEFA, it holds that the reinstatement cannot outweigh legal certainty. So moving on to the appeal brief, which was late. We would like to also highlight that it is according to the 2019 CS case of Club Sportive and Jose Paulo, it is of the mandatory nature of this rule that late filing of appeal makes the whole appeal inadmissible. Now, I would like to move on to issue D, Professor Chen. Issue D is I would like to talk about issue D, which is a refusal to hand over the phone. In this, I will mention 2 points, which is Mr. Fortuna breached the duty to cooperate under Article 12 of the FDC, and he cannot rely on self-recrimination under Article based on the facts. Now, Article 12, subsection 3 of the FDC requires a person subject to the court to help establish facts and provide evidence requested. Mr. Fortuna is bound to it because of the mere fact that he is a part of the association of FIFA and part of the national team itself. The duty is general but real. On the facts, Mr. Fortuna immediately refused to surrender his phone, according to record paragraph 20, page 4. And he maintained that refusal despite repeated requests, according to paragraph 21 of the record. Now, this mirrors the same principle in Jerome Valque at paragraph 277, where refusal to provide requested documentary evidence constitutes a violation to duty to cooperate. Now, I understand that my opposing counsel relies on Article 6 of the ECHR, but we would like to argue that this FIFA proceeding is of a civil private disciplinary proceeding and not criminal. In Jerome Valque at paragraph 263, CS held that the criminal trials guarantees are not applicable per se in FIFA disciplinary proceedings, and FIFA is a private entity under the Swiss association law.
I think the opponent's point is that there are some parallel prosecution proceedings here, right? And so whatever procedural and evidential rights that are compromised in private civil FIFA proceedings may have knock-on effects in those proceedings. That's my understanding of the argument.
Professor Chen, I would like to shine light on what I said earlier. We are not contesting that Article 6 does not apply in this case. We are just saying that the threshold of Article 6 is very high to meet. And I understand that opposing counsel and your question refers to the notion that FIFA shared those documents while there was parallel proceedings going on. FIFA shared these documents with the public prosecutor. But our submission is that because Mr. Fortuna did not share anything with for the proceedings itself, FIFA had to go out of their way to make sure that they can facilitate and start the proceedings just to start the proceedings itself, and then they can chase Mr. Fortuna regarding this issue. This is evident from the record itself because the Iridonian public prosecutor refused to share evidence with FIFA and will only do so at the end of the investigation. This can be seen on the record at paragraph 15 and 16, page 4.
So when FIFA requested the phone, did it provide or undertake anything with respect to safeguards and whatnot? I mean, ordinarily, you wouldn't just hand over someone your phone, right? You would expect certain guarantees in return.
Yes, Mr. Professor Chen. We can see from the record itself that FIFA guaranteed that they will not share. public prosecutor guaranteed that they will not share any of the documentary evidence with FIFA itself. But because of the nature and because how Mr. Fortuna outright refused to submit his phone itself, the public prosecutors had no choice but to share this information with FIFA. And we concede to the fact that FIFA shared these documents, but going forward, it is also to be noted that they also mentioned that we will only share the rest of the evidence at the end of the investigation. Professor Chen, I understand that I have elapsed my time. If I could have 1 more minute to answer your questions and sum up my last submission.
Yeah, kind of as long as you need.
Right. So, Professor Chen, now lastly, I would like to talk about the consequences and the adverse inference. So, under the IBA rule of evidence under the IBA rule, which is International Bar Association, Article 9, subsection 7, the tribunal may draw adverse inference when a party refuses to produce requested evidence without satisfactory explanation. And the IBA guidelines of party representation, Article 26, subsection B, permits appropriate inference where the misconduct affects evidence. Therefore, we would like to submit that Mr. Fortuna's refusal to support the request should be taken as an adverse inference. And as compared to the serious integrity cases where the non-cooperation attracts a far harsher sanction, such as the 2020 case of Naden Nova and PTIO, the fine which is appropriate for this scenario is CHF 10,000. So for these very reasons, FIFA respectfully asked the panel to declare the appeal inadmissible on issue A, and in any event, find Mr. Fortuna's refusal unlawful and permit adverse inference. If Professor Chen does not have any further questions, I would like to now hand over my time to my co-counsel, Mr. Austin Seah, who will be covering issue C and issue D. Thank you.
All right, thank you.
Good afternoon, Professor Chen. As earlier introduced by my co-counsel, Mr. Mark Maxwell Peter, I'll be addressing the remaining 2 issues on appeal. Now, turning to the third issue, we agree with the appellant that Article 6 of the ECHR is instrumental in understanding whether anonymous evidence can be admitted, and there are 3 factors laid out in the Article 6 ECHR guide that has to be fulfilled. Firstly, there must be a good reason for non-anonymity. Secondly, the evidence itself must not be sole or decisive. And lastly, there must be counterbalancing safeguards in the event of no physical cross-examination. Now, the appellant had earlier claimed that there needs to be a real threat and raised the case of the 2019 CAS decision of Karamuddin. But as rightfully noted by Professor Chen, the likelihood of violence is higher for gang violence in such match manipulation cases. And to provide evidence of that, if I may turn Professor Chen's attention to PDF page 32, paragraph 6.
Yes.
It is noted that the appellant's father has friends in the criminal world. Now, in the 2019 case of Karamuddin, it was noted that there was a power imbalance and criminal allegations, which is similar to our cases, which does increase the risk of intimidation. And therefore, there is a good reason for the witness to remain anonymous. And Professor Chen had also noted that apart from this threat itself, it can also result in the fact that the witness be treated as an outcast, and we do agree, and therefore this forms another good reason for anonymity. And now, turning to the second element, it's noted that we do not rely on this anonymous witness statement or email in isolation. In the 2009 case of F.K. Bobeda, the decisive question was whether the evidence is corroborative rather than decisive, and whether it fits an overall evidentiary matrix. And in that case, the panel relied on objective betting anomalies, reinforced by financial criminal links, witness statements which provided contemporaneous context rather than proof of their own. And to show that there's internal consistency in the fact that there's corroboration, if I may turn Professor Chen's attention to PDF page 33, paragraphs 9 and 10.
Yes.
It is noted that the appellant said to his father to stop pressuring him, then after a couple of minutes, finally stormed out. Well, this ultimately ties in with the anomalous betting, and if I may turn President Chen's attention now to the Genius report at PDF page 12, 6 paragraphs under the title header.
Yes.
It is noted that betting for Combatland picked up pace 12 hours before the match. Now, it is crucial to note that this phone call also took place the night before the match, and therefore it can be said that the inference can be drawn from the fact that the appellant finally acceded to his father's request to take part in the match manipulation, which gave the father the ability to tell his members to ultimately place their bets for Combatland, the opposing team of Iridonia, and to provide
Right.
another form of
Okay, so let's go back to the anonymous witness first, because I think whatever you are covering now, in a sense, is looking at the facts through that prism, right? So let's resolve that prism first. I believe the opposing counsel raised a couple of other points as well in relation to the witness, right? One, your right to confront or to cross-examine that witness. Do you accept that there is such a right? And secondly, the opposing counsel also suggested that there might be some ways in which you can protect the witness and still verify some of the information. But here it seems that the fullest extent of the witness's cooperation is the giving of this statement and nothing else. So doesn't that has that ever been done successfully in the case?
Certainly, Professor Chen, and I'll answer your question in 2 parts. Regards to the right to confront the witness, we do agree that in the case of Karamuddin, there was audio-visual protection to safeguard the witness's identity. However, turning now to the issue of internal and external consistency, it is noted to be a factor which does serve as a counterbalancing safeguard. There is an alternative to audio-visual protection. And in that case, they checked whether the statements were coherent, whether they acknowledged their own limitations, and whether they avoided exaggeration. And in our case, the witness recounts a stress phone call while, and I note this critically, acknowledging the limits of what he could not hear or not. He did not speculate about any betting arrangements or manipulation, but confined his account to what was personally observed. And now turning to Professor Chen's second question about the right to protect the witness and to verify the identity, we also agree that this is a balancing exercise. But we have to consider the context of match manipulation, as noted in the 2009 case decision of F.K. Pobeda, where it cannot be proven by a smoking gun. And therefore, in light of the recent increase in match manipulation cases, this court should be taking a more proactive stance into the admission of evidence. And we also have to consider the repercussions of forcing the witness to testify. Now, as noted by Professor Chen, this witness is inside the team of 10 individuals, therefore making identification rather simple. And if the witness ultimately chooses not to even provide a statement in the first place, it goes to show that match manipulation in our case could possibly not have been proven because there was no one to corroborate any evidence. And therefore, we submit that this panel should be considering admitting these evidence. I note my time, and unless I may be of further assistance on the third issue.
I mean, you will have time eventually. So I'm curious about the interplay between the prosecution and these proceedings. Would there be any double jeopardy if let's say there's a conviction in the prosecution?
Certainly, Professor Chen. Now, we do note that it is possible that a prosecution could find that Mr. Antonio Fortuna was guilty. And in this respect, FIFA would take its directions from the prosecution. As noted, in the case of a criminal proceeding, the standard to establish a criminal violation is that of beyond reasonable doubt. And now, in our case, if the prosecution was able to satisfy this extremely high threshold as compared to a mere balance of probabilities, a mere comfortable satisfaction in our case, we would take directions from the prosecution to find that Mr. Fortuna was guilty. And now turning to the fourth issue regarding match manipulation. In essence, opposing counsel's argument centered around why each piece of evidence does not prove guilt. However, the legal approach required in such cases is not whether each individual piece of evidence can prove guilt, but rather if all the evidence taken in totality satisfies the comfortable satisfaction that this panel must meet. And this is the precise method and threshold set out in the 2009 case decision of F.K. Pobeda and the 2019 decision of Karimudin. And earlier, Professor Chen asked about the methodology of the report, and we would submit that it actually shows how objective this report is. If I may turn Professor Chen's attention to PDF page 24 under the title Dual Analysis Review.
Yes.
At this juncture, it notes that there are two analyses that are confirming the nature of their investigations. And this two analysis framework prevents any confirmation bias and increases analytical reliability. And with respect to the second part of that, the performance analysis paragraph, it does note that former footballers and special officiating teams come together to reach a calibrated consensus. Therefore, the appellant's submission that this report is purely subjective is unfounded because there's a detailed level of research and objectivity that goes towards this report, and therefore this report can be relied on this panel. And now, turning to the first element that's to be made out to find match manipulation. Firstly, there must be an act or omission attributable to the appellant that manipulates the course of the match. And sufficiently, the conduct of the player that forms part of the omission is needed. And now, turning the Professor Chen's attention to PDF page 15 at the 23-21 benchmark of goals. Mr. Fortuna misjudges a lofted pass, resulting in a score of combat land. And at the very next page, regarding the passages of interest, at the 5-minute and 54 mark, there was a corner that also passed through Mr. Fortuna's hands. And at the 44-25-minute mark, there was an unnecessary touch that led to a hurried clearance, rebounding to an open goal. Now, counsel for the appellant has claimed other reasons for why Mr. Fortuna has failed, and specifically relied on the fact that Mr. Fortuna's teammate had underperformed. However, poor performance by his teammates does not tie in with the pre-match anomalous betting. If I can turn Professor Chen's attention to PDF page 14, under the conclusion on pre-match betting.
Yes.
Professor Chen, I note that my time has elapsed if I may address the rest of your queries.
Please.
So at this juncture, it notes that there was unjustifiable betting support even before any of the players stepped onto the field. Therefore, poor performance of this teammate does not collaborate with the fact that there was betting anomalies. And therefore, there is no correlation or corroboration with the appellant's claims. And now the Professor Chen had also asked the weight of such betting reports. Crucially, we are not relying on the betting report itself to establish a claim. Rather, we do note that this betting report in itself is insufficient to establish a match manipulation claim. But noted together with the performance analysis, the anonymous witness statement and emails, we can ultimately satisfy the threshold of comfortable satisfaction. And this brings me to my second element as to whether the appellant was directly or indirectly involved. And as earlier noted, there was a phone call made by the appellant to his father, which directly ties in with the betting anomaly link. And this is considered indirect manipulation, which was accepted in the 2014 case decision of Sivasspor and UEFA, which noted that benefit and coordination can run through third parties and indirect manipulation is sufficient. And unless I may be of further assistance on the last issue.
No, I think that'll be it. Thank you.
Thank you, Professor Chen.
Thank you, Professor.
Professor Chen, if I may begin.
Yep.
Okay. I have 2 points in rebuttal. Firstly, with regard to anonymous witness evidence, opposing counsel himself concedes that there are 3 conjunctive elements. Now, what's to be noted is that these are not factors to be balanced, but rather that each element has to be proven. And when we look at the third element on counterbalancing safeguards, the current case does not meet the threshold. The precedent case that opposing counsel himself relies on, which is Karim Karamuddin, had stated that the most important safeguarding factor was the fact that there was cross-examination that was still conducted with audio-visual protection. Here, that is not present, and thus the threshold for the third element is not met, and this evidence should not even be admitted. And with regard to Article 20, there are 2 elements that have to be proven. There has to be a conspiracy, and secondly, the appellant must be linked to the conspiracy. Now, we do agree that the totality of the evidence points towards there being a conspiracy. However, this link between the appellant and the conspiracy can only be shown by 2 pieces of evidence. 1, the fact that the appellant had a call with his father, and 2, the alleged poor performance of the appellant. Now, my co-counsel has already established that the performance of the appellant is exculpatory, if anything, and the call with the appellant's father has no context as to what was said from the father's end. Thus, when opposing counsel says totality of evidence, it is referring to these 2 flimsy pieces of evidence that cannot meet the sufficient standard of comfortable satisfaction. I end my rebuttals.
Thank you.
If I may begin, Professor Chen.
Please.
Professor Chen, 2 points in Sir rebuttal. The appellant has characterized the fact that audiovisual protection is a strict condition and has to be followed. But however, in that case, they do also acknowledge that internal and external consistency does form as an alternative factor. And to turn to the policy considerations for why this panel should admit the anonymous witness statement, it does form or it does tie in with other pieces of evidence that forms the threshold of comfortable satisfaction and was similarly relied upon in cases such as F.K. Bobeda and the cases of Karamuddin. And the second point of Sir rebuttal is that there must be a link between the 2 pieces of evidence, and counsel for the appellant has noted that they are flimsy. However, they are flimsy on its own if they stand by itself, but when ties in together with the objective betting report, as I've established earlier, to be reliable due to its nature of its source, we do note that these 2 pieces of evidence tied together following the mosaic approach in F.K. Pobeda does satisfy the level of comfortable satisfaction. Unless I may be of further assistance to the panel.
All right. Thank you.
Thank you.
Mhm.